The Moab North General Adjudication. My name is Blake Bingham. I'm the Assistant State Engineer. I'm responsible for the adjudication program throughout the state of Utah. Appreciate you all coming out. Just a quick introduction of some key players, and they're kind of out in the hall still answering some questions, but just so you can put some names and some faces. We have Mark Stilson over here at the iPad and tie. He's the regional engineer. So he'll kind of be the point man for a lot of the boots on the ground. So this is Mark Stilson coming in right here. He runs the regional office that has the responsibility for this area. And so his office is really going to be executing the boots on the ground stuff, all right? I have some other support staff in the audience that are also answering questions. Josh Zimmerman outside, and then Mark also has his support staff. I have Ben Jensen from the Attorney General's office who represents the state engineer. So just quickly, some rules of engagement. I know when we send these notices out and the summons are with them, it's a kind of an intimidating thing to receive a summons from the state of Utah. I just want people to understand that you're not obligated to be here at this meeting tonight, that the summons is sometimes a little bit unclear with regard to that. But it is a judicial or proceeding, and so that's why the summons is necessary. If I had my way, we wouldn't be required to send summons out, but because it is a legal proceeding, that's just the way it is. So also, as we go throughout the presentation tonight, I'm happy to take any questions that you have. If there's some real hard questions, I'm just going to point to Mark and let him answer them, and then you can send all your hate mail and everything to him later on afterwards, all right? His contact information will be on the last slide, so be sure to copy that down and send the hate mail his way. But without further ado, let's go ahead. We are also recording this as well as live streaming it on our YouTube channel for people to tune in at home. People who have questions, who are viewing online at home, if you have a question throughout the presentation, you see the email there at the bottom of the screen. If you fire off an email before the presentation is concluded, I'll check my email, and I'll try to answer the question for the benefit of the group. If I don't get to it, or if you send the email too late, I'll still answer it. It'll just be later on tomorrow. So here's our agenda. We have the adjudication overview. I'm going to talk about what a general adjudication is, what it means to you, to the people on the ground, and some of the process and procedures associated with that, including what a proposed determination is. And that's a word you'll hear often tonight. We'll kind of break it down Barney style for everyone involved so that we all have a common understanding of what the next step is and what the implications are to both water right holders and the public at large. We'll talk about some significant issues, anticipated timelines, and again, questions at the end, but please feel free to ask questions throughout. Usually what happens is everyone's really timid to ask questions during the presentation, and then finally someone works up enough courage to ask a question, and then the floodgates unleash and everyone asks questions, and it's hard to move on to the next slide. So once that first question's broached and you feel like you're comfortable asking, feel free to do that, but I might get to a point where I just need to advance to the next slide so that people can listen to the entire presentation. We already got our first question out of the way. So the YouTube channel, that's a great question. So it's on our website. So it's waterrights.utah.gov/watch live. So that is where it's currently being streamed live, okay? And we'll, again, record that, and then it'll be posted to you can go to that same link, and it has a URL or a link that will take you to past videos. So you can also see this exact same presentation to like 20 different groups in Salt Lake Valley and other parts of the state. A lot of the same material, just kind of tailored and tweaked to the Moab area for tonight. So let's go ahead and get started. So what is a water right? So we talk about these concepts of general adjudications and proposed determinations, and really we talk to audiences with vast levels of experience, whether they're brand new, don't even know what a water right is, or they're very in tune with what a water right is. So I like to try to bring everyone up to a common level of understanding and first describe or explain what is a water right. And so When we talk about a water right, it's really the right to divert water or remove water from the natural source and then beneficially use that water, whether that's for irrigation or stock water or domestic purposes. But it typically has 5 different components to it. The first being the most important, and that's the nature of the beneficial use. So in Utah, the beneficial use is the basis, limit, and measure of a water right. So when we talk about how big is your water right, we're not really as concerned about how much water, we're more concerned about how many acres of irrigation, how many head of stock, how many houses, because that's really the basis of what a water right is in the state of Utah. So that's the first and most important aspect or component of a water right is the nature of beneficial use. The next is a priority date. And the priority date, in essence, tells you where you are in line with respect to other people who are diverting water from the same source. And in Utah and most of the arid West, we operate off of this system of prior appropriation where first in time is first in right. And we'll talk a little bit about the historical context and how Utah evolved into that concept as well as the rest of the West here in a little bit. We have a defined quantity of water, and we typically measure that in a flow rate by cubic feet per second or an annual diversion measured by acre feet, an annual acre foot amount. And if you can imagine a yard that's an acre in dimension and water 1 foot deep, that's what an acre foot is, exactly what it sounds like. We talk about a specified point of diversion, and that's just a fancy word for saying where the water comes out of the source. So whether that's the well, or whether that's the spring box, or maybe a head gate off of a ditch, or off a stream or a creek, or anything like that, that's what we call the point of diversion. And the specified place of beneficial use, that's exactly what it sounds like. That's where the water is being used. Although we measure that using the public land survey system. I'm not going to get too far into the weeds, but we have a particular way in Utah to identify where that place of use is being put, where the water is put to beneficial use. So when we send these initial notices out, we do this in the Salt Lake Valley quite often, and even get some of these phone calls from people in more rural areas. They call us up and they say, well, I don't know if I have a water right. And so we typically kind of walk them through the discovery process of whether they have a water right or not. And usually, water rights, people typically know whether they have water rights or maybe shares in an irrigation company or something, because there's usually some type of fee associated with an irrigation share. But for a water right, there's usually some type of structure that you are either maintaining or pouring money into, such as a well, a spring box, or a head gate, right? And so usually people who have water rights are pretty familiar with these structures. And so that's kind of where we start off with, do you have any of these things on your property? Sometimes people are just fishing. They don't know if they have a water right. They think it's kind of like a mineral right. It's flowing underneath their ground, and it's just something they have. But generally, water rights are evidenced by these types of physical structures. What a water right is not. So there's a lot of confusion between a water right and a water share. And so we'll just kind of make that distinction up front. A water right is something that the division of water rights you have in order to beneficially or to divert water and beneficially use it. Now, a share in an irrigation company is just like what it sounds like. You own a share of ownership in that company, but the company owns the water rights. So they own the big water right, and then they distribute water based on the shareholder's interest in that company. So they're not necessarily the same thing, although they both kind of physically manifest themselves in similar ways in that you're diverting water and you're applying water. However, when we talk about the general adjudication process, really water right owners are the ones, or claimants are the ones we're interested in participating in this. Now, does that mean if you have an irrigation share that you can just ignore this and not worry about that? No, actually I would encourage you to become involved to make sure that the company itself, the shareholder, or excuse me, the board or the president is actively engaged, because they will need to file a claim on behalf of the irrigation company itself, all right? So, and some companies are a little bit more robust, have a little bit more robust command system or infrastructure, and some are just kind of, as I like to say, ran out of the glove compartment box of an old Chevy pickup truck, right? And so they may not be quite as in tune with some of these proceedings. So make sure that your irrigation company is involved in tracking this. Another thing that a water right is not is a connection to a public water supplier, like a local municipality. So if you have, a lateral coming in through a meter to your house, there are water rights for that, but the public water supplier like Moab or some service district owns those water rights, and they will be participating in this process on your behalf. And for the most part, public water suppliers understand or are engaged in this process. You probably don't have to worry about them as much. Okay, so when I do this presentation, I like to provide a little bit of historical context just so that you understand, first of all, why are we coming in and getting everyone hot and bothered, sending summons out, getting people mad at us, and thinking the state engineers taking them to court. So the historical context provides a little bit of understanding of why we're doing what we're doing and where we're at in the process. And so as most of you know, the story about the advance party of Mormon pioneers who came in July 23rd, 1847, and started diverting the waters of City Creek just to soften up the soil so they could kind of get a late season crop in. And then, I don't know, if those of you who've been to Salt Lake City probably recognize that they then built their shopping mall on top of it. About a year later, Brigham Young made somewhat of an interesting statement. He said, "There shall be no private ownership of the streams that come out of the canyons. These belong to the people, all the people." And that's really a basic tenet of water rights in Utah. Okay, the water isn't owned by the state. It's not owned by the people. Well, excuse me, it's not owned by individuals. It's a resource owned by everyone in the state. Okay, the division of water rights, we don't own it. We simply regulate the distribution of it to make sure it's equitable among those who own water rights to it. And so, if you kind of look at the waters of the state of Utah, it's just a public resource, and that's really what it is. It's not owned by anyone in particular. It's just a natural resource we have. Well, between 1847 and 1850, what we now know as Utah started off as a part of Mexico and then kind of transitioned to this quasi-ecclesiastical state of Deseret and then finally into the territory of Utah. However, the government or the governing body was church-centric. Just because the LDS Church was the only real authority in the area, it filled that power vacuum. As a result, diversions of water were generally based on how the community needed. They're done on a communal basis. Brigham Young would send settlers north and south, east and west, and as the settlers would reach their destination, they'd start diverting the waters of the natural stream sources and applying it to where they hoped to grow a crop. And so those first settlers, they did a lot of the work for that. They dug all the ditches. They cleaned out. They plowed all the ground. They did a lot of the work to improve those diversions. Well, the doctrine of priority kind of evolved out of that concept because you had the initial settlers who put a lot of the work into building those diversion structures, and then you had subsequent settlers who would come in later, and being kind of neighborly, they wanted to make sure that they had the water they needed, and so how they treated that is said, well, the first settlers, you guys have a primary right, meaning you get to take all the water you want, and then whatever water's left over, the subsequent settlers, you can have that following once our rights are satisfied. And that kind of evolved into this primary and secondary rights system. And interestingly enough, Utah was one of the first states to come up with that, and that eventually spread to other states later on. Well, because the church was kind of the authority in the area, all conflicts were kind of settled through those ecclesiastical channels. You had bishops' courts for local issues, and then if they didn't like what the bishop had to say, they'd take it to the stake high council, and the stake high council would make their determination. And so they were doing the best with what they had, just because there was no formal government in place yet. Well, as we turn the corner and we move on into the territorial era, there was an attempt in 1852 for the first territorial legislative assembly to migrate power away from the LDS Church into, the the governing body, right, as it should be, right? And so what they did is they gave the county courts the authority to distribute timber and water privileges in any course of any of the creeks. And this was all fine and great, but until you realize that the county court positions were all elected positions, right? And so who do you think the Mormon pioneers are electing to those positions? Well, it's going to be their bishops and their stake presidents, the same people who are already distributing the waters in the first place. And so really, this really didn't have a whole lot of change or effect on what they were trying to do. And Salt Lake County was the only place that really it took hold. For most of the rest of the territory, it wasn't really followed. Well, in 1877, Congress passed the Desert Land Act, and this was an effort to get people, to incentivize people to come out to the West and populate the West, homestead it. One of the requirements for homesteading is you had to irrigate. You had to develop a crop, and you had to actually improve the area. Well, that's really hard to do in an arid state unless you have water. And that wasn't a big issue back east because water was plentiful, and if you owned property adjacent to a stream or a river, you had an automatic right, called a riparian right, to divert water as much as you want. Plus, you had natural precipitation, which was generally adequate to grow whatever crop you were attempting to grow. Well, the result of this Desert Land Act is that it essentially severed title of water and land. So in essence, it said that, hey, you don't need to own land adjacent to a stream in order to get irrigation, which the pioneers were already doing. He said you can divert water, carry it a long distance, and apply it to the ground. And so and another subsequent evolution of this is that through some case law, it in essence said that all the counties, all the territories and states, they had the authority to administer water rights in whatever fashion they deemed necessary, which to us seems reasonable, right? You know, the state should be in charge of administering these water rights rather than the federal government. But at the time, it's kind of a big deal because the government still was issuing land patents, right? The federal government still, the GLO, the Government Land Office, they were still issuing patents. So you might think it's pretty commonsensical that, hey, they may as well do the water as well. Well, this is, in essence said, all right, states, it's up to you to figure out how you're going to administer water rights. And so each state, Wyoming, Colorado, Utah, we were all left to our own devices, and we all came up with different systems, interestingly enough. Well, one of those first systems was the attempt to give power to these county selectmen, who were kind of ex officio water commissioners, and they would go around and issue certificates and water rights to people. But again, it was generally ignored, and really, I think, my understanding, it was ruled as unconstitutional, something having to do with the executive branch having control over our property rights rather than the judicial branch. So again, it didn't really do anything. As a result of that, confusion continued in spite of the best efforts of the territorial legislature or even the LDS Church. And the church continued to administer and decree water rights. A case that I often cite is the 1879 LDS Church High Council decision, which divided the waters of the Spanish Fork River. And that Spanish Fork River is largely still divided along that initial High Council decision. Certainly there have been subsequent decrees, but that's originally how it was distributed, and it largely is to this day. Well, as we kind of go into statehood, there was a little bit of, when Utah became a state in 1896, there was a body looking to determine how are we going to figure out these water rights issues. How are we really going to administer water rights in this state? And there was some fear that the state was going to go and confiscate all the existing water rights and then start administering them back out. And so there was a lot of controversy over that, and some warring parties, different parts of the government had some fights over it, and they decide, fine, we can't come to any reasonable conclusion, but what we will do, we won't talk about anything about water except for one piece in the Constitution, Article 17, which states, all existing rights to the use of any of the waters in this state for any useful or beneficial purpose are hereby recognized and confirmed. So all that said is, hey, if you've been using water, you can continue to do so. You've, in essence, been grandfathered in, all right? And that was all they said. You know, you have this entire body of law, Constitution, and this is the only thing they felt like they could agree on moving forward. So the question of how to appropriate new water rights or record older water rights was still kind of up in the air. Well, in 1897, the Office of the State Engineer was created, but his powers weren't really, didn't really have anything to do with appropriating water rights. His responsibilities more had to deal with mapping existing streams and determining what the amount of how much water was available in those streams and those types of things. Appropriations were kind of made in the old-fashioned way, where you'd go and stake your claim at the source, and you'd go record it in the local post office or at the county recorder. Again, that was largely ignored. Well, in 1902, the United States Reclamation Service, what we now know as the Bureau of Reclamation, was established to reclaim the arid West. And they would do this by going into parts of the western United States and building large reservoirs. And the purpose of those reservoirs, is much different than what we think of them today. We think of them for motorboats and then those types of recreation venues. But really what they're there for is to promote irrigation and to promote farmers to have a steady supply of water so they could irrigate through the summer season. Well, the Bureau of Reclamation was very reluctant, actually adamant, that they would not build any of these projects in any state or territory that didn't have a comprehensive water law that dealt with appropriating new water rights, but also recording an existing old rights. Because what they were worried about is they'd come in, they'd get all the funding, and they'd build these large reservoirs, but there would be all these unknown existing rights, all these grandfathered rights that they didn't have any idea existed. And so they'd build this dam, and then they'd realize all these existing rights already are there, and they have no rights to actually fill the dam up with water. So they said, hey, states, unless you get some type of water law passed, you're going to be out of luck. So no coincidence that the state of Utah passed the comprehensive water law the very next year. It dealt with appropriating new water rights as well as adjudicating the existing rights. So the adjudicating rights, is you kind of get the sense of the word adjudication, had to do with a judge, right? Well, unfortunately, in a judicial setting, it is an adversarial setting, meaning you need a plaintiff and a defendant. Unless you have a plaintiff and a defendant, judges don't go around looking to issue water rights certificates or determining existing rights. They need the court case to come to them, and then they kind of pontificate and weigh facts of law, questions of law and facts, and make a decision, right? So unless the court case comes to them, they're not really well equipped to make determinations of water rights. And plus, Congress or the legislature failed to provide any funding for them to do that. So there really wasn't any adjudicating of these old grandfathered rights done. Well, in 1919, the state legislature finally figured out, hey, we need to fix this. We're not figuring out these old rights. We got to understand where these rights are so that we can appropriate new water rights. Because the theory was, hey, we will figure out all these old grandfathered rights, and then we'll start appropriating new water rights. And that's how it was started off in 1903. Obviously, it didn't get anywhere, so they figured, well, what we need to do is we need to give the state engineer the responsibility for going out, and he's going to do the audit. He's going to figure out all these old water rights and get an assessment of what these water rights are and how they should be administered, and then he's going to provide the court in a proposed determination his opinion. And then the court's going to look at that opinion and join all the parties and make a ruling on the state engineer's official opinion. And that's largely how we still do it today. The state engineer has the statutory responsibility for going out, doing an assessment of all the water rights in an area, identifying old existing rights as well as new appropriated rights, and bringing them before the court and saying, hey, this is what the rights look like, this is how we think they should be administered, and the court gives the hominis dominus decree, and then they're off to the races, right? I failed to mention that 1903 law was only for surface water rights. At the time, you could still drill a well without a water right because they felt like surface water and groundwater are two different waters. But we now know better, and they kind of knew better back then, but they just didn't want to deal with it. Well, in 1935, they finally realized that, hey, maybe we ought to require a water right for wells because it's the same water. So the law governing surface water rights was established in 1903. The law governing underground water rights was established in 1935. And those are two key dates that will come into play here in just a little bit. Let's keep on going. So prior to the enactment of those laws, water rights kind of fell into one of 5 different categories. You had those water rights that were decreed through ecclesiastical fiat, by the bishop's courts or the state high councils, those types of things. You had those that were filed for record at the county. Again, there aren't very many of those. I've only seen 1 or 2 in my tenure at the Division of Water Rights. You had those rights that were decreed by a court. However, those typically only involved limited parties. So, for instance, if me and Mark had an argument over our water rights and we took it to the court would only rule between me and Mark. He wouldn't rule between me and Josh because Josh wasn't a party to that lawsuit. So really, those decrees were only affected those 2 parties, and that's as far as they were. And so they weren't really comprehensive, and plus you had a judge who has no real experience in either hydrology or agriculture or engineering, making these determinations about water rights. Now, certainly they had expert opinions and those types of things, but there are many cases where judges over-appropriated rivers through decree just because they didn't have the tools to really make an informed decision. You had those water rights that were based on agreements among different parties. They didn't involve the state, didn't involve the courts. It's just like me and Mark, hey, you have that water, I have this water, why don't we switch? And then we'll switch back. I like your canyon water, or you like my lake water type of thing. That's pretty common at least in the Salt Lake Valley. And then you had those claims that really never manifested themselves on any type of record whatsoever. These are the guys that were continuing to use their grandfathered rights, didn't feel a need to really bring them to the attention of anyone and continued to use them. And so they never filed a claim, and those still exist. We call those diligence claims, people who have rights that predate 1903 for surface rights or groundwater rights that predate 1935. So as a result of the lack of definitive water law, there are a couple issues. First of all, there's no public record. There certainly wasn't any consolidated public record where people could go and find out what water rights were in what area. Because there was no record, over-appropriation was rampant, and it was common, and it still is today. And because rights weren't of record and they weren't defined, there were a lot of controversy. People would take each other to court and try to get it solved. And obviously that's a bad thing. We like to all get along with regard to water, but if there's a lack of clarity, sometimes that's difficult to do. Well, in his biennial report in 1901 and 1902, the state engineer at the time, A.F. Dormis, made this comment. Now, keep in mind, this is before they had established the comprehensive water law. I think it was in the works to get some type of water law on the books. But this was his vision for how this should unfold. He said, the definition of existing rights appears to be of first importance. These are rights that were the grandfathered rights. He said, this is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made of public record. So the theory was, again, hey, we're going to figure out all the old rights, and then we'll start appropriating new rights. Well, it didn't work out that way. It took too long. The courts never really took any action on determining these old rights, and so they started appropriating new rights anyways and just expected the adjudication to catch up. Well, we're finally catching up. Here we are in Moab, 100+ years later, we're trying to catch up piecemeal at a time throughout the state. So what is a general stream adjudication? Well, as the name implies, it's an action in court. It's actually an action in state district court, which is significant. I'll explain why here in a little bit. It binds all water users, including the state engineer, so everyone within the drainage. Rather than doing this piecemeal litigation, it binds everybody in one comprehensive suit. That's the title of code it's governed by, Title 73, Chapter 4. And the first general stream adjudication took place in the 1920s. You recall that that's the 1919 law gave the state engineer the responsibility for preparing the proposed determination. As you kind of look at this map, and I realize it's impossible to see back there, especially these texts, but all these different colored polygons or blotches on the state of Utah represent different general adjudications. And they're typically delineated by the respective river drainage that they are in. And so when we talk about the Moab adjudication, we're really talking about a subdivision of the Southeastern Colorado River general adjudication, which commenced in 1957. Now, if you were able to see this, you would see that there are a couple areas, such as the Sevier, the Virgin, and the Weber River, that were started back in the 20s. And a lot of these other ones were initiated in the 50s, and I'm going to explain why 1952 is kind of a magical date in the realm of adjudication here in a little bit. But as you can see on the state map, there isn't any place in Utah that hasn't had an active adjudication take place in it. Now, there are some that have been completed, like the Sevier, the Weber, and the Virgin. But even the Virgin River, they said, hey, we're not satisfied with this adjudication, so they reopened it back in the 80s. But the rest of these are still actively being pursued, or still active adjudications. So why do we conduct general adjudications? Well, we want to bring all the claims onto the permanent record. Remember this guy? He's diverting water up in the mountains or somewhere, didn't need to file a claim. Well, we want to require him to bring his claim forward so that we know that there's water being used and diverted. For groundwater, for surface rights, we usually refer to those as diligence claims prior to 1903. For underground claims, or underground water claims, those are prior to 1935. Those are the wells that were drilled prior to 1935. Sometimes we lump, in current day parlance, we lump those both together and just call them diligence claims. So if you hear diligence claims, just understand it's really the word for a pre-statutory claim, meaning it's water that was being used prior to the statute's enactment by the state legislature. The next right that we want to bring on the permanent record of this is this concept of federal reserve water rights. And we could do a whole separate presentation on this. There have been books written about federal reserve water rights. So I'm going to give you kind of the thumbnail sketch of where these came from and why they're important to us and how they tie into a general adjudication. First of all, back around the turn of the century, the Native Americans on the Fort Belknap Indian Reservation were trying to become more of an agriculturally based people. That was kind of the edict. That's why Congress carved out the Fort Belknap Indian Reservation and required the Native Americans to go and reside there. Well, as they went there, they said, well, we need water to do this. And so they turned to the Milk River and turned to the state engineer of Montana and said, hey, we need to appropriate some water from the Milk River. And the state engineer of Montana said, sorry, my friends, all the settlers have already appropriated all the water out of the Milk River. You are out of luck. And the Native Americans, as you can imagine, kind of wondered, well, how are we supposed to do what you told us to do if we can't get water to do that with? And so obviously they took it to court and actually went all the way to the Supreme Court. And rightfully so, the Supreme Court ruled that, hey, because Congress had mandated this and reserved that ground from the public domain, that there was an implied water right for that ground, for that reservation, hence the term Federal Reserve water rights. And so the water right for that Indian reservation had a priority date equal to the date the reservation was established, which predated a lot of the settlers' water rights, and so they were able to divert some water out of the Milk River and satisfy the demands that they needed. Well, this concept or this theory, this case law, was subsequently applied to other types of federal reservations. So not just Native American reservations, but also Forest Service reservations, national monuments, national parks. All of these have this Federal Reserve water right associated with them. And you might ask, well, what does that mean? And I would respond with, nobody knew. They just knew that they had a water right. And the state didn't know, and the settlers around didn't know, and the federal government kind of liked it that way. And they're like, well, we just have this water right, and it's superior to everyone else's, and we're just going to use it whenever we want to. But it was really hard for people to plan and to do what they need to do with this kind of this cloud of water right over them, right? This Federal Reserve water right. So there was a senator from Nevada in 1952, Senator McCarran, who didn't think this was particularly fair, especially in the West, where a lot of the land in the West is owned by the federal government, especially the Forest Service. And so he drafted some legislation that, in essence, said, hey, the federal government waives its federal sovereign immunity. So for those of you who don't know, you can't sue the federal government unless the federal government allows you to sue them, right? So it's kind of one of those things that will never happen unless they'll never happen. But the McCarran Amendment essentially waived the federal government's sovereign immunity with respect to general adjudications, allowing states to sue the federal government and forcing the federal government to show up in state district court to defend their water rights, to quantify their claims and defend their water rights. And so it's a unique feature of the general adjudication in that we can force the federal government to A, quantify their water rights that they're making claims against, but also do it in a state district court. And so that's why it's important to the state of Utah. We obviously have a lot of federal inholdings. We have national parks. We have a lot of Native American reservations, especially in the Southeastern Colorado River general adjudication. We have the big Navajo reservation. We also have, obviously, some national parks. So these are Federal Reserve water rights that because of the general adjudication, the government has to quantify, which beforehand they didn't. They were just saying, we'll use whatever we want whenever we want it. So it's important. Let's keep moving on. All right. Another reason why we do general adjudications is we want to avoid a multiplicity of suits. We don't want people suing each other. We just want to sue everyone all at one time and get it over with, right? Pull off the hangnail in one fell swoop rather than doing it little bit by little bit. Okay, here's kind of the more controversial aspect, and this is usually when I get a swarm of questions, all right? So in the western United States, a basic principle is that we don't have enough water for everyone to satisfy all the demands that they want, right? It'd be great if we had all the water in the world. Well, we don't. And so that's why we have this doctrine of priority. But we also have this doctrine of use it or lose it. And so this was implemented by the state legislature back in 1903 that said, hey, if you fail to use your water right, it's subject to being forfeited by the courts, meaning you either put it to beneficial use or you let somebody else use it. And this is really a method to ensure that people are incentivized to use their water. Because if you think of it, and this is kind of where it gets people, their eyebrows start getting twitchy and getting nervous. Well, why are you taking the water rights? But if you kind of turn it on its head and think about, so if you don't use a water right, if you don't use your water right, that water is going downstream and it's being used by someone, right? In the state of Utah, that water is absolutely being used by someone, even if it's California down off the Colorado River somewhere. But it's being used by someone. We won't go into that. But it's typically being used by someone downstream. And so if you think about it, if you fail to use that water and entire communities are built, or houses are built, established on those junior water rights, and then you suddenly 50 years later come in and say, oh, I'm back, I'm going to use my water right, and you start diverting water, well, entire communities have become reliant on that water. And so that was one of the reasons why the state legislature felt it was necessary to have that use it or lose it clause. And Utah is not alone. In most every single western state has that type of law to ensure that water is being put to its best beneficial use. So that's that. So in Utah, it's if you don't use your water right within 7 years, it could be potentially subject to forfeiture by the courts. Or if you only use a portion of it, the unused portion could be subject to forfeiture. And so we want to kind of get rid of some of these rights that aren't being used so that we have a clearer picture of what water is truly being used. And I know that's critical here in the Spanish Valley as well, as you guys are kind of embarking on this groundwater management and study and these types of things. I know there's a lot of concern over the water table in this area specifically. And so part of this helps to bring clarity to that. So all these abandoned rights get removed off the books and we don't have to count them towards what's actively being diverted. Because right now, we're not really certain. And we have a lot of water rights. We have a lot of paper water. But how much real wet water of that paper water is being diverted? Well, general adjudication helps to bring some clarity to that by removing some of those abandoned rights from our records. Lastly, the general adjudication seeks to obtain a final comprehensive decrees on all the water rights, including those old diligence claims, those old pre-statutory rights. And ultimately, at the end of this is a court, is a judge with a gavel who issues the decree saying that these rights are recognized and they become decreed rights. Let's talk about the adjudication process. It's really a three-phase process, and boy, you don't really see the color very well in that. So let's back it up just a little bit. Let's talk about the first phase here. The first phase culminates with this public meeting right here, step 4, right? With the petition for the Southeastern Colorado River adjudication was done long ago, back in the 50s. Notice was sent out. We published notice in the newspaper. We sent out summons. That's part of the packet that you received in the mail. And we sent that summons to both water right owners and property owners within that map that's in your packet, all right? And that's just to ensure that everyone is apprised of this proceeding, that everyone has an opportunity to participate. And then we're holding the public meeting right now. The next phase, and I'm going to go into these different phases in much greater detail in the next few slides, so don't feel bad if I kind of breeze through this really quickly. So the next phase is going to include notice being sent to you, and then an opportunity for you guys to file claims on those water rights. So if you have a well, you'll need to file a claim on it. For water rights of record, so here's another kind of buzzword I'll throw out a lot. Water rights of record versus water rights not of record. Water rights of record are those rights that we know of. We have a big file room both in the Price office and in Salt Lake City that has all these folders with water right numbers associated with it. So those are the water rights of record that I'm talking about. Water rights not of record is that Dos Equis guys, you know, he hasn't filed his claim yet. Those are the water rights we don't know about. Those are the ones that predated statute. So they're still out there. We don't know about them. So I'm going to talk a little bit about water rights of record right now. So as people receive this notice, if people fail to file a claim on a water right of record, again, a water right that we have on our records in the state engineer's office, those water rights go on this list of unclaimed rights, meaning no one's filed a claim on them, no one's interested in securing them and perpetuating them, so they go on this list. People have 90 days. You'll receive notice. People have 90 days to look at this list. Hey, that's one of my water rights. File an objection and then say, no, I intended to file a claim. I just got hung up doing something else, or I was out of town, or something to that effect. But once that list goes past the 90 days, the court will issue a decree adjudging that all those water rights of record are abandoned. By virtue of the fact that people have failed to come forward and claim them, the judge will just say, hey, no one's interested in these rights. We're going to get them off the records. And they just go away. They don't go into some warehouse and then we sell them later or anything like that. They just become non-valid, all right? And so if you imagine the stack of paper water rights, and we have all these water rights of record that are abandoned, we just take that big chunk of water rights out, and everyone's water right moves closer to the front of the line in priority, right? So it's just a way of kind of getting rid of the ones that no one's interested in. And we have a lot of that, I believe, here in the Spanish Valley, but we have a lot of it in the Salt Lake Valley as well, where people have drilled wells, and then the local municipality finally caught up with them and provided culinary service to their house, and so they just abandoned their wells and never really needed to pursue it any further. Or later on, farmers' fields become Walmart parking lots, and the irrigation goes away. No one's interested in claiming those. Again, we'll have a public meeting, and I'll go into a lot more detail about this, and then people have an opportunity to object to that, and we resolve it before the court issues that decree. Kind of the final phase involves the claim investigation phase, where if you file a claim with our office or with the court, one of our team members will come out and make contact with you and evaluate the claim that you filed. So if you filed for the well in your backyard and you're irrigating with that well, he'll come out and look at the well, get a grid coordinate, GPS grid coordinate, make sure we have it in the right spot, and then we'll map out the irrigation or whatever the beneficial use is associated with that. And then what we do is we get we kind of go back, we evaluate it, we make a recommendation, and we compile all of our recommendations in this proposed determination that we then file with the court. And the court then people have 90 days. If they don't like the recommendation we make to the court, they have 90 days to file an objection. Say, hey, I don't like how the state engineer trimmed my irrigation in half. I really do have 40 acres, not the 20 acres he mentions, or some other mistakes we may have made. And for the most part, if they're honest mistakes, we have no qualm in correcting it. But if it's something we don't agree with, we may end up litigating that out with whoever files the objection. But we have to resolve all of those objections before a court can issue a decree on the proposed determination. So let's kind of, oh, sorry, there's that third final phase. So you got the kind of claim investigation, the proposed determination, 90 days to object. We hold another public meeting like this. A final summons, which is kind of like a, hey, this is your last chance. If you haven't filed a claim, do so now. And then the objection resolution and the court decree. So let's talk about filing your water user's claim. So in about 2 weeks from now, if you receive notice for this meeting and the summons, you'll receive another notice. And in that notice, there will be a copy of the summons, just to make sure you got it. But there will also be a notice to file claims, as well as a claim form. Now, what that claim form looks like depends on two things. If you are simply a property owner and you're not on our records, you're not an owner of a water right of record, you will receive a blank water user's claim form. It's just a standard form, has you just fill it in, all right? We don't expect people to really understand all the terminology and the jargon. So we encourage people to call our office or come into the Price office, come in the Salt Lake City office if you're up that way, or give us a call, and we'll help you fill the form out. We'll walk you step by step so that whatever you need to claim makes it onto that form. For those of you who are water right owners of record, or owners of water rights of record, you'll receive a claim form that's already filled out, okay? It'll have all the information that your original appropriation or your original claim had that's on our records. All you need to do is simply sign and send it back to the state engineer's office, or you can file it at the district court. So you have 90 days from the date that that notice is sent out, and I think we're shooting for May 4th is when we're going to send that notice out. I get the thumbs up from Josh in the back. So around May 4th is when we're going to mail that notice out, and you'll have a 90-day period in order to file your claim. If you feel like you need a little bit more time, you can request an extension within that 90 days for an additional 30 days. You can simply email me, or there's a form on our website. I'll show you where it's at. It's easy if you just email me or Mark, and then we just respond saying, by virtue the fact that your extension was filed consistent with some statute, you have a 30-day extension, and we'll give you the new deadline for it. So just know that's available. But you need to file your claim within that initial 90 days or the extended 120 days if you get an extension. Otherwise, you will be barred from participating any further, right? This is kind of like that, no kidding, do this, file your claim. If you come out of this meeting with anything else, file your claim, all right? Get your foot in the door. We can always fix it later. Just get a solid claim in there so that we know that, hey, you're participating, and then we can work on fine-tuning it later, okay? It doesn't have to be perfect. Don't, as my brigade commander used to say, don't let the perfect be the enemy of the good enough, all right? And we don't want that to happen here. Just get your claim in, and we'll work with it to make sure it gets where it needs to go. Once we get your claim, a member of our staff, probably Mark's staff, will be contacting you in an attempt to schedule an appointment to come out and validate your claim. Look at the well, or look at the ditch, look at the irrigation, look at the house, and if the well's connected to the house. Just make sure that whatever you're claiming is there is actually there, okay? We aren't going to do a whole lot of in-depth study, or not going to do a whole lot of, I say investigation, but it's really just a review of your claim in the field to make sure it passes the common sense test. When we do that investigation, we will then prepare what we call a state engineer's recommendation, and we will mail it back out to the claimant. So once we've evaluated it, we'll go back to our office, we'll do our tabulating and all that good stuff, and then we'll come up with what we think the water right should look like, if it's different than what you're claiming, and we'll send you our recommendation back to you, just so you know what we're looking at is going to be published in the proposed determination. Now, that gives you an opportunity to hit us up and say, hey, this is what you said you recommended, but you missed this or you missed that, and then we'll retool it and kind of fine-tune it a little bit. So let's talk about list of unclaimed rights. This is a relatively new feature in the general adjudication. So some of you may have participated in previous adjudications in this area, in the Castle Creek area or even the Taylor Flat area. This feature, this list of unclaimed rights, was not around when we did those previous adjudications. So this is something to pay attention to, okay? And we've already kind of hit on it a little bit. Remember the water rights of record. If we don't receive a claim on it, they go on this list of unclaimed rights. We'll send out notice, so if you receive a notice to this meeting, you'll receive a notice of the list of unclaimed rights and how to access it so you can go down there and make sure none of them are yours. And then we'll hold a public meeting. You have 90 days from when that notice is sent out to file an objection with the court. Now, as part of that objection, you need to file a water user's claim for the right that you're objecting to, okay? So that's part of the objection process. Again, if you have questions on what that means, we're certainly happy to give you kind of an azimuth and a pace count on how to get there. But because it is kind of a legal proceeding, a legal objection, we can't really draft your objection for you. We aren't attorneys, but we can show you some examples of objections that have been filed to help get you there. So we're not opposed to people filing objections in this. We want people to claim those water rights. We want them to use them. We understand that sometimes you just miss the time frame. But you got to file them with the district court, and then you have to provide a courtesy copy to the state engineer. Once that objection is filed, the state engineer is obligated to resolve the objection. For the list of unclaimed rights, we really don't spend a whole lot of effort trying to battle people who file an objection. Again, we're interested in people filing claims because we can always evaluate it later if it's valid or not. So for the most part, unless it's just completely ridiculous, we don't fight those objections. We pretty much just let them go, and we file a motion to the court to say, yeah, we're fine with it. Let them file their claim and let the right be removed from the list of unclaimed rights. Again, we don't take a hard stand position on that. I will say this, though. At least in Salt Lake Valley, about 75%, 50 to 75% of the rights we have of record end up on that list of unclaimed rights. That's how much development has taken place since they had these rights, and how much interest, a lot of these well rights have just vanished. And I'm not sure what the percentage will be for the Spanish Valley, but I expect that there will probably be quite a few rights of record that get put on this list of unclaimed rights. Just because my understanding is some of these wells have stopped producing and people aren't interested in really pursuing them, or they've been paved over or knocked over or whatever. Once the objections to the list of unclaimed rights have been resolved, the court issues that decree saying that those rights are now considered abandoned. They're no longer any good. You can't use them. You can sell them if you want, but you can't divert water under them. Another feature of that decree is it prohibits anyone from filing a new diligence claim in that area, meaning, hey, if you've had one of these old rights, these old grandfathered rights, now is your time to file it, because after that list of unclaimed rights gets decreed, you will simply be banned from ever doing that. So up till this point, you could say, hey, my great-great-grandfather diverted water, and you could provide the evidence to that effect and file a diligence claim or even a pre-statutory pending adjudication claim, and we could recognize it. But once this decree happens, tough luck, Chuck, right? You can't assert those claims any longer. Let's move on to the proposed determination. So the proposed determination, as I've already talked about, is really a consolidation of all of our recommendation into one book, all right? And it's just, in the book reflects how we think the water rights should look like. As well, with this proposed determination, we also prepare a hydrographic survey map that kind of correlates. You've seen the map out here. It's like that, but there will be a little bit more in-depth, and it'll have any irrigation mapped on it, as well as any recognized points of diversion. And so we file those with the court and hold another public meeting. In contrast to the previous public meetings we've had, the people who file a claim are the only ones who will receive notice of this, other than through the newspaper. So unless you file a claim or actively participate or file something with the court, you won't receive notice of this proposed determination or this public meeting. You're certainly welcome. It'll still be available for you to look at. We just aren't going to waste the stamp if you haven't participated up to that point. Similar to the list of unclaimed rights, you have 90 days to file an objection. That objection needs to be filed with the court. Now, these we are a little bit more reluctant to accept unless it's an obvious omission or anything along those lines, and we probably won't help you file it. We feel, up to this point, we've investigated claims, we've made our best determination. Unless it's just an obvious clerical mistake or some obvious omission, we will probably end up trying to oppose your objection if we feel that the state engineer's recommendation is what it should be. And so that usually ends up in some type of negotiated settlement proceeding or even litigation if both parties feel like their case needs to be heard. So there's that. And then once we get all the objections resolved, either through litigation and the court orders them dismissed, and the court could order the state engineer to amend the proposed determination to the benefit of the objector, and that's happened, or you could dismiss the objection and say there's no merits to it and the proposed determination stands. Either way, we have to resolve those objections before the court can issue a decree confirming the proposed determination or modifying it in connection with any objections that had been filed. So here's the map that you received on your notice, and I don't recall if the map you had all these little purple dots, right? These cluster of dots. Those dots represent points of diversion for water rights of record that we currently know of within this adjudication boundary. There's approximately 581 of those that we know of, current existing rights in that area. So all those dots represent an individual water right. Most of the water rights in this area are underground wells, and we sent out about 4,500 notices / summons to this meeting tonight. Of that, it looks like about 200 people showed up, which is actually, that you may think that's not a lot, but that's actually a lot better than what we get in Salt Lake. So I applaud you for your concern and your participation. So issues and anticipated timeline. This may be the fastest I've ever gotten through this presentation because no one has asked a single question except for the gentleman at first, but that's all right. We'll have plenty of time for questions. So issues, out-of-date title to water rights on the state engineer's records. So often what happens is that people buy and sell property, and sometimes those properties have wells on them, and the person who appropriated the well with the original property, well, the water right remains in their name. Even though the property gets updated at the county, the records on the state engineers, our records, don't get updated when that property conveyance takes place. And so, although you are probably, in fact, the owner of the property and probably the owner of the well and the water right, on our records, it will probably still reflect the original owner unless what is called a report of conveyance is filed, which in essence establishes the chain of title from the original appropriator to the current owner of that property. And so you may receive a notice at your house for your address under someone else's name with a water right for the previous owner of that house. It's very possible it could happen, right? And that's because
you may be the owner of the house and the owner of the water right, but you just haven't updated records with our office. Now, do you have to update records with our office in order to participate in this process? The answer is no. We encourage people to do it, but you can do that in parallel with the adjudication process. As far as we're concerned, you can file as a claimant on the water right, and we just say, yeah, you're filing as a claimant, but it preserves the water right, and then you can update title at a later date when you have a little bit more time, because there's a little bit of a process involved depending on what the chain of title looks like from the original appropriator to the modern day successor in interest. Also, we have these things called no proofs required. These are water rights where, so if you are familiar with the appropriations process, typically how it looks is you appropriate a new water right, you file an application, the state engineer says, yes, you are approved to drill that well, and then you have so many years to show beneficial use, and then you're required to file a proof on that water right to show that you've actually developed it and put it to beneficial use. Well, during the World War II years, there weren't a whole lot of surveyors or engineers who could file that proof on the behalf of those water right appropriators. And so the legislature felt like, well, for small amounts of water, we're fine if people just appropriate these and we won't require them to file proofs, which is great, and it helped a lot of people out. The problem with it is those points of diversion, or the location for those wells, was never really firmly pinned down very well. It was estimated in the application. So they could have said, we're going to drill the well here, and then the well driller gets on site and said, it's a miserable spot. Let's drill it 100 feet over here. We're going to drill it over here. And so the location never gets checked by an engineer or surveyors. And so when you look at these dots on these maps, you have to kind of take them with a little bit of a grain of salt, all right? They may be off because it was never surveyed in. There's also other variables that play into that with respect to GIS and also the state survey system, whether there was actual monumented survey corner and whether that point was actually surveyed from that monumented corner. So there are a lot of variables that play into that reflect that maybe that manifest themselves in an inaccurate location on the map of where that well actually exists. So those would just be issues to be cognizant of as you go, and I'll show you our interface, our web interface, where you can go to the aerial imagery and see what wells are nearby. And you might see, well, there's one right in the middle of my house. I don't know, my well's in the backyard. You just got to kind of take it with a grain of salt. Hopefully through the adjudication process, we can square that away and get better fidelity on the location of where that well actually resides. So let's talk about the anticipated timeline. I already talked about May 4th is when we're going to send out the notices to file claims. That 90-day claim filing period then commences. In July is when that 90-day claim filing period will conclude, and we'll begin investigating or reviewing these claims as soon as they come in. But that's when, after that 90-day period concludes, that's when the bulk of the work really takes place. Sometime in November, we hope to publish that list of unclaimed rights. So people have 90 days to file a claim. Then there's some additional extensions added onto. So around November-ish is when we think, all right, we finally have all the claims that are going to be filed. Let's publish this list of unclaimed rights. Once that's published, the 90-day objection period for the list of unclaimed rights commences, and it would conclude in February. And these are kind of just estimated time frames. There's nothing that's hard and fast about this. Around August 2019 is when we think the proposed determination will finally be ready to be published. Hopefully it's before that. Just kind of depends on how quickly we can get through these claims, how complicated they are, and what issues we come up against. And then in November, so when we publish the proposed determination, the 90-day claim filing period commences, and that will conclude in November of 2019 if we do publish in August of 2019. So, with that, here's the question I usually get in spades over and over in different ways throughout the presentation. Will I lose my water right? And really the biggest thing to take away from this is if you have a water right and you're using it in line with how the state engineer is authorized or how it's delineated on your water right, you have really nothing to worry about as long as you file a claim within that 90-day period, all right? And if, you know, I'm not sure if you stomp your foot and say, file the claim, if that's going to drive it into everyone's head to just file the claim. That's the biggest obstacle sometimes for people. And we try to make, and we understand we have busy lives and not everyone wants to spend time dealing with a mid-level bureaucrat and filing claims. I get it. Totally understand. But we try to make it as painless as possible. Individuals without a water right of record, remember these are the grandfathered rights, are required to file a claim, otherwise they risk being barred from participating in the future. And then those water rights that are that have fallen out of use for a period of 7 years or more, or even a portion of it has fallen out of use for a period of 7 years or more, may be subject to being disallowed. We call it disallowed, and then the court is really the governing body who has the authority to declare it forfeited. So we simply recommend to the court that, hey, this water right hasn't been used, or a portion of this water right hasn't been used, and then the court makes the final determination. So, where to send your hate mail? This guy right here is the best place. You can also send it here or here, not so much this guy. But I'm happy to answer any questions. You know, feel free to hit up any of these individuals. They'll be able to give you the right answers. I think both my information and Mark's information is on that frequently asked questions page. Again, we can probably send you in the right direction, whether we can answer it or not, or whether we can send it to a staff member who has boots on the ground, understanding they can answer it for us. So with that, are there any questions in general? Yes, sir. And you have to speak up, and I'll try to repeat it for the benefit of the crowd. So his question is, looking at the map that's part of the summons, it looks like only portion of the Spanish Valley is part of this adjudication. Is that correct? And the answer is, it's correct and not correct at the same time, and I'll explain. We're cutting the Spanish Valley in half, so we're doing this portion first, and then the remaining portion will be done once we get done with this. There was some concern that we would just be overwhelmed if we tried to do the entire Spanish Valley in one fell swoop. There's just too many water rights, too many people, and we wanted to make sure that we were able to dedicate enough resources to really nail it. But yeah, the answer is that the remaining half of the Spanish Valley will also be adjudicated in a similar fashion. Yeah? Okay. His question really delves into how the adjudication for the northern part, or it will fit into the pending groundwater management plan. And I can't really speak with respect to the groundwater management plan. I can tell you that how it will tie in is we'll get rid of water rights that are no longer being used. It will clarify that picture, so at least we'll have a better picture of what water rights are still being used, so that they can understand, hey, how, you know, as part of the plan, and I can bring Mark up and he can speak to the groundwater management plan portion, but this will at least provide some clarity on the front end, so that on the back end, the state and the people of the Spanish Valley can come up with an adequate plan to move ahead to make sure that there's the sustained yield is met or not depleted for the groundwater. Do I have a question back in the back? Yes, sir.
I have two questions. For those of us who have already filed water use claims, we filed one. Do we need to refile claims?
That's a great question. Let me just restate. So there's some people that have filed water users claims as part of what's called an election, right? And that's a whole different thing. But just know that there are people who have filed claims. And his question is, do I need to file a new claim as part of this? And the answer is no. If you filed a water user's claim, that's different than an application to appropriate. But if you filed a water user's claim, we count that as satisfying that 90-day requirement. You can always file a new one if you want and amend your claim, but it's not going to affect the basis of the right. But to answer your question succinctly, no, you don't need to file a new claim. Did you have a second part to that question?
Yes, sir.
So yeah, his question is if you received the notice, well, he's asking if you receive the notice in our name, do we need to worry about whether the previous property owner is the current owner of the water right? And my answer is there's probably nothing you could tell from the previous round of letters to discern that. What we'll be telling is in this next round, if you receive a water user's claim that is already filled out with your name on it, that means that you are the owner of record. If you receive a blank water user's claim and don't receive anything else, that means there's a potential that you aren't the owner of record for that water right.
And if we do receive that notice, water user's claim
in your name,
in our name, we don't need to worry about it.
yeah, so if,
If we receive it and it is in previous owner's name, then what?
yeah, so his question kind of along those lines, if you receive this water user's claim and it's in your name, you don't need to worry about it, correct. You're the owner of record on our records, so you're good to go. If you receive it and it's in someone else's name, or if you receive a claim that's just blank, then you probably ought to start worrying about, if you know you have a well, getting title to that well updated. And there's a process called a report of conveyance. We can walk you through that. That's not really my wheelhouse. It's a whole different section. It's a title section issue. But the regional office can help you navigate that process as well. Yes, sir.
Well, I was told about that outside there, that file a report of conveyance, I should hire a lawyer or an engineer. I can't do it myself.
So his question is, to file a report of conveyance, do I have to hire an engineer or a lawyer? I almost said liar. Lawyer. Why can't I do it myself? And the answer is yes, you can't do it by yourself. The statute requires some type of title professional. So whether that's an actual title professional, an engineer, a surveyor, or an attorney, those are the title professionals who can do that. There are certain instances where you can do it yourself, and that's where if the previous deed to you specifies the actual water right number. But otherwise, it takes someone who has experience with the title to certify that that chain of title is correct. And that's really what they do. They're taking the liability upon themselves to certify that that chain of title is correct from the previous owner to the current owner. And I know that might ruffle some feathers, but the challenge is we used to just accept deeds, and we used to just process the title, but what we found is it caused way more problems because without someone who's an actual title expert who can certify that chain of title and that a search has been done at the county recorder has been done, there's no way to really know whether you're truly the owner or whether that title went off to someone else somewhere along that chain. So that's the reason why they require a title professional. But so if you're going to look for the cheapest venue, surveyor or probably title professional, and I would defer to the regional engineer, probably ask some names of people local who can help you out do that. And the cost depends on the circumstances of the chain of title, how far removed you are from it, and what the circumstances of the evolution of that chain is. But yeah. Any other questions? Yes, ma'am. Okay. Her question is, what if you live in an area or subdivision, you don't have a water right, you don't have a well, but you want one for future development purposes? My understanding that the current policy in this area is it's still open to new appropriations. Whether that changes in the future is going to be, I think, a result of this study that's ongoing and the state engineer's efforts to understand exactly what's happened with the groundwater. So I can't speak for the future, but currently the policy is you can appropriate a limited amount of water. I believe it's for 1 acre of irrigation and a residence is kind of the policy per parcel. So, any other questions? Sir. You have to say it again. I had a hard time hearing you, sir. Oh, So his question is, will this adjudication process help people to acquire new water rights? The answer is no. To acquire water rights, you have kind of a couple different choices. You can either purchase a water right from someone else and move it to your well, or you can, in this area, which is pretty unique in the state of Utah, you can appropriate a new water right for a limited amount. But the adjudication really doesn't facilitate that, other than bring it to their attention that they maybe need to do that. So, yes, sir. Oh, yes. Okay. I was going to avoid airing our dirty laundry, but since you brought it up. All right, so his question is, he received a summons for the Moab Subdivision, and there's probably a few of you out here that did as well. So this is the challenge of being a state organization, trying to run a state program and relying on another state organization that doesn't care as much about how mailings go out. So I'm not going to throw state mail under the bus, but in this case, it's their fault completely. What happened is we were doing a summons for a different subdivision, which is Murray, which we had the public meeting for last night. Notices went out at the same time. We had a couple extra printed off just in case they needed the extra notices, and they forgot to take the notices out of the hopper before doing the new mailing. And so there's probably a few in Moab that received that notice for the Murray. I apologize. We're trying to work with state mail, state printing, to avoid that from ever happening again. But you will receive a summons in the next, it will be corrected in the next one, and we're going to stagger the mailing so this does not, so we limit the opportunity for state mail to screw our mailings up. But sorry, I apologize for that. It's one of those things. We were embarrassed when it happened, and we apologize for any confusion or heartburn that may have caused to the public. So thanks for it. Yeah, and so if you receive another summons, that's why, because we've got to certify that everyone received summons. So we're going to send another summons out. It's not a different lawsuit or anything like that. It's just we've got to do that so we can certify that people were served with summons. So. Any other questions? Let's go over here, sir.
I have a well that I've been using since 1974. I think everything is perfectly legal. I did not receive any notification or any stuff.
So he says he has a well he's been using since the 70s. He has every reason to believe that he's completely on the up and up. But for some reason he did not receive a summons. There's some reason why this may not apply to him. The only reason I can think is either your property is outside the boundary delineated on that map. I'm not sure. In that case, you wouldn't have received a summons for this particular adjudication. Another reason may be that the county recorder didn't provide us with your ownership information. That's where we got the mailing list from. But once you meet with us and we can look at the map and see where you're at, and we can get your contact information and make sure you're on our mailing list moving forward. And it may be the case that the well you have is probably in the name of someone else, and the notice that was associated with that well went to some bad address somewhere. Or maybe it was, and some of these are old addresses like Rural Route 1, and they just get automatically kicked back to us because the post office doesn't know how to handle those. So we can take a look at it afterwards. Okay. Is there a question here? So say that again. Sorry. So his question had to do with, he didn't see anything in this last notice that we sent you that had anywhere for you to fill anything out or claim anything, right? And his question is, when will you receive that? You'll receive that in the next couple of weeks. It will be another notice, a summons, and then an actual form that you can fill out on it, okay? If you have any questions, just contact the number on the notice, and we'll help you fill it out. Do you have a question, sir? So this question is, how long after they file a claim do we come out and review the claim? And we really don't have a good feel for that. It depends on how many claims we receive. We try to do it in kind of a systematic approach so that we're just going to one area on one day, rather than kind of all over the place. So there's no really exact time frame. it just kind of depends. Now, certainly if you feel like, hey, I'm only going to be home during this time or at this period, contact us and we'll come and look at your claim. There's nothing magical about the date. It just, as they come in, whoever the staff is available, however Mark wants to handle the staff and distribute those, they'll come out and make the 2-hour journey down to look at the claim. So, but we can certainly, we try to accommodate your schedule as best as we can. Yes, ma'am. Mm-hmm. Well, this is a great question. Right. So her question has to do with her particular scenario, and then we see a lot of this in Salt Lake Valley and probably here, I imagine, where the house was built, they had a culinary well to satisfy the domestic needs for the house. They've since connected up to a municipality to provide water service. And her question is, are we at risk now that we're connected to this municipal connection of losing our rights because we don't use that well for our residents anymore? Can we transfer it to irrigation? The answer is yeah. You can file a change application. Probably won't get a whole lot of irrigation out of a domestic water right is the thing. You almost just easier just to file a new application or something like that because you already have the well. But the answer is we'll preserve the beneficial use if it's being used in an unauthorized fashion in the adjudication. We just annotate it on the claim that, hey, this was authorized for a house, it's being used for irrigation, it needs a change application, but since it's continuing to being used, it's still recognized. So if it's being used for something else, there's been some case law, some Supreme Court case law, which suggests that protects it from forfeiture. So we've just adopted that and said, all right, it's not an authorized use, but they're still protecting it. But in this area, you're lucky where you're not going to get a whole lot of irrigation out of a domestic water right. I'm going to tell you right now, you might get like less than 1/10 of an acre of irrigation out of a domestic right based on the depletion. But Mark probably has a better calculation for that than I do. So you're almost better off just appropriating a new water right for the irrigation of your yard since you already have the well. But you can fill those out with the local staff to see what the best course of action is. Yeah, so there's a couple ways to skin that cat as far as keeping the domestic. I mean, I'm not sure if the local municipality requires you to complete your well from your house when they connect it. Okay, and so there's some instances where we simply just say, hey, they're connected to the municipal supply, but they still want to preserve the option to use that well connected to the house. And so what we say is they still have the right to do that. The well is just not the sole supply to that house. And so in essence, that well becomes valueless outside of being connected to that house. You can't sell it. It just isn't worth anything outside of you using it with that house. It's kind of just to recognize that, hey, they can still use it, but they're relying on the municipal water supply in lieu of the well. So, yeah, this gets really in the weeds, and maybe we should talk one-on-one because it's not super intuitive. Are water rights like a bank? Is there a question in there? Yeah, so I think your question is like, how can you best manipulate these water rights to your advantage? Can you sell them off and appropriate new water rights? So in Salt Lake City, it's really popular to own water rights because they're worth a lot because you can't appropriate new water rights. So any water right you have is like super valuable. I assume that they are less so in this neck of the woods because you can still appropriate new water rights, right? So to try to get someone to buy your domestic water right, why would they do that when they can just go appropriate a water right for a limited fee? They still have to drill a well. So there's, I won't get into the philosophical merits of trying to scheme the system and to your advantage. I welcome everyone trying to do that. That's great. I just don't think it's a viable framework in this neck of the woods to make a buck, probably, until Mark closes down the valley. Then money, 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 right? All right. And anything else? Any other questions? Yes, sir. So, sorry, you have to speak a little bit louder. I couldn't hear you. Okay. Yeah, so if you're in Emery County, you're probably going to be in the next phase of this. If you're in the Spanish Valley, and we can look at that we can look at the map and see where you're located and kind of give you some heads up when we might be in your neck of the woods. Okay. But you may have received notice. I'm not sure why you received notice unless you have property holdings within this area. So, any other questions? I am going to demonstrate really quick on the computer how to use our website so you can look and find out some of this information. So if you're interested, staying around, it will continue to be projected, but I'm going to work from the computer over here, and I'll speak in the microphone so you can follow along. So you can decide to do whatever you want to do, but just if you want to stick around for that. Oh, hold on, I do want to check to see if there's any questions that were asked from our online viewers here really quick. Here we go. I actually got one. All right, the question reads, this is from Chris and Wendy. Hello, my husband and I own land in Kayenta Heights with a water right. We have not yet built a dwelling on the property. Assuming our water right is confirmed, how long will we have before we need to build the house and begin using the water? Well, that's a good question. I'm not sure from this question whether the water right is been perfected or not. Let me see. So it sounds like it's still an open appropriation because they haven't developed the house yet, and so they haven't filed proof. And so really, the question is, have they used it? If they haven't used the water right in the last 7 years, the answer is we're probably going to we recommend to the court that it be recommended to be disallowed. As far as how much time do they have, if it's a new appropriation, there's a time frame built into that appropriation when you file the application. I think it's 7 years. I don't know, 5 or 7 years. You know, get that from the engineer out there on the appropriation side of the equation before you have to file proof. You can seek extensions, but Wendy, if you still have questions, feel free to give me a call or give Mark a call. We'll help you out. I don't know that answered your question. I think I need a little bit more detail in order to help you out totally on that. So I'm going to make my way over now to this computer screen. We can go off camera, but I'm going to be on mic. Oh, did I get another question? Oh, I got another question here. Sorry. This is from Karen. My property used to be part of the neighbor's property. They have a well but are using municipal water. I'm connected to municipal water. Do I have any rights to their water rights? The answer is I don't know, Karen. Probably not. If it's their water right, I don't know how you would lay claim to that. I guess we could look at the water rights database and determine whether you are a part owner of that water right from a previous subdivision or not. But there's no automatic, you can't simply say, I want part of their water rights. That would be akin to someone saying, I want part of your dog or something. You know, you can't just go take stuff without asking people. So probably not. If that didn't answer your question, feel free to give me a call. All right, I'm going to move over here and then show you how to look at our website. All right, for you guys playing along at home, I'm going to project this on the big screen. I'm just going to go to our local web browser. I guess I actually have to plug into the internet. Let's see if this one is open. No? Let's see if that works. Success. So this is our web page. Can you see that up there? Great. I'm going to kind of zoom out a little bit here, see if I can maybe, so we can get the whole page on the screen. How does that look? Oops, not meant to do that. Okay, great. Okay, so this is our website. If you want to view this presentation at a later date, this little training video over here is a great, if you can see my mouse cursor, that will take you to our YouTube channel where you can view this presentation as well as sundry other water rights presentations. But what I want to show you first is the map search feature. That's the link right below it. It says map search, so in the bottom right hand corner. If you select that, it'll bring up an aerial imagery, kind of an Esri map interface for the entire state of Utah. I'm going to go up here and take off the points of diversion just so that it doesn't get overly busy too quick. Now I'm going to zoom in to Moab, all right? All right, here we go. So, downtown Moab. Now, when you get here and you want to find your house, there's a couple ways of doing that. But first I want to show you some of these features on the right-hand side. The first one is this, this feature called Points of Diversion. Now, you recall this will show all the points that we have on the map. It'll show you all the wells and stream sources. So the red icons are where are locations for wells. The blue icons represent surface diversions, all right? And so those maps out on the map out there, those dots out there represent these wells. So if we kind of zoom in, you can go and you can select these wells and it'll bring up some more information. In this case, this is a water right, 05-1719, in the name of Brent and Tracy Bullock, all right? It was appropriated in 1980, the appropriation date, the priority date's up here. That means 1980, February 4th. And you can even go and select that hyperlink and it will take you to our website that has all the information about that particular water right. So the ownership information is up here. Let me grab my laser pointer really quick, hold on. So the ownership information is the first item you come to, and then below it you have a bunch of the filed information. It was filed in 1980, and it talks about what type of water right. It's an application to appropriate. As you go down, you can see it was appropriated for 0.015 cubic feet per second. It's not a whole lot. It's usually associated with a domestic use, but in this case, it looks like this water right is used solely for quarter acre of irrigation. And you can see that by this field down here. I'm going to move my cursor for the online viewers' benefit. And I'll show you with the laser pointer. Irrigation for 0.25 acres. And then it shows in that matrix below it the location of it. And I won't worry too much about that unless you like to dive into the public land survey system and figure out what that means. Up here is where the point of diversion is located. Again, that's measured from a section corner. So if you wanted to read that, that would say south 1,230 feet, west 849 feet from the north quarter corner of section 1, township 226 south, range 21 east, Salt Lake Basin meridian. So, and there's some other features you can kind of click around. One of the features up here is you pull up this drop down and go to scan documents. it will show you all the documents we have on the file for this particular water right, including, hey, this one has a water user's claim already on it, all right? So this is probably, they've signed an election and they filed the water user's claim in lieu of submitting proof, okay? So this is what an old school water user's claim looks like. This is not what the current ones look like, but they essentially have the similar type of information. So these guys wouldn't need to file a claim within that 90 days. They already considered to have filed one. But there's other sundry information. I'm going to go back to the map feature and show you some other cool things about this. First of all, we can bring up this block that says adjudication books. And so for those of you who are wondering whether you're inside or outside of the boundary, if we bring up the adjudication books layer, I'm going to turn the points of diversion off just because it's kind of crowding everything out. You see the purple lines, those are the individual subdivisions. So that 052, that's the Moab North Subdivision. Then the one to the southeast is 055, that will be the Moab South Subdivision. So that's the one we're going to do later. It's a little bit bigger geographically, but if you pull up the points of diversion, there aren't quite as many points of diversion now. It's not going to show me just because it will only show so many points of diversion at a time. So if you're curious about, hey, is there a well? Oh, are you all right, sir? Is he all right? You're all right? Yeah. Okay. Other than a little, oh, I'm sorry. I'll try to make it a little bit more entertaining for you here. So if you are not great at navigating maps to determine where your address is located, up in the upper right-hand corner under the search tab, you can hit search and then drop down and you can search by an address, okay? So who wants to give me their address and we'll do a quick search for them? Any volunteers? 1700 Murphy Lane. Oops. Moab. And we hit search. And it'll take me to X marks the spot. And we can go back to our layers tab and turn on the points of diversion and show you that there's a well near, well, it shows it's in the middle of the house. It's probably not actually where it's physically located, but yeah. And so that's the water right that you're probably is associated with your well. Ralph Leo Christensen.
Here's the situation with the post office. The name and the number doesn't match. It's going to go back to that's under the name of Pilling and he's deceased. That will come back to you because the name and the number don't match.
Okay.
That's the way the post office says check your regulations. It's already in there. So if the well is in Pilling's name, Filling 1700.
Well, the well is in name of Ralph Christensen. Well, the name's in Ralph Christensen. So yeah, it probably won't get delivered to you because if the well's not in your name, but the property, you'll still receive a blank claim form for whoever the property owner is. So you'll still receive the notice.
You don't know that there. If it goes back to you in the name of Filling.
Well, I don't know who this Pilling character is, but right now the water right is in the name of Ralph Christensen. That's the one we have on file. That will come back to us, but the property owner, which I presume is you, listed on the county records, that's the name and address we would send a notice to as well. Did you receive notice tonight to come to this? Did you receive the notice to come tonight?
We did, yes.
Okay, so you'll receive it.
But it was our name, not to
Yeah, that's what I'm saying. We're going to send a notice in your name.
get the property owner's name.
Whomever received, whatever was in the name of the notice that you received for tonight, you'll receive a similar notice with a blank water user's claim form.
What happens if there's a wet spot that's been abandoned? It's not file on that.
Sorry, say that again?
What if there's a wet spot that's been abandoned?
What if there's a wet spot that's been abandoned? Well, I'm not sure what a wet spot really is, a seep. You can always file whatever you want to file. I talked to the regional engineer about filing. As far as filing a claim on it, probably not. But filing for a new water right or appropriating new water right, that may be a possibility. All right.
The water would not be utilized, but it's definitely.
If the water is not utilized, then you probably want to think twice about spending money on trying to appropriate a water right for it if you're not going to use it for anything, is my guess. But okay. So are there any other questions about, we can talk offline afterwards about your particular situation, but let me cover some other website features if that's all right. Okay. Well, we can certainly talk that. I just want to, for the sake of the viewers, I want to show them one other feature on this.
Those are the only thing I had. Just make sure your address is right. And
well, if you received the notice tonight, then I guess we got it right.
can I file in a wet spot?
Probably not.
It's already developed. We developed it one time, probably 30, 40 years ago.
All right. I don't know. File away. Okay. You can always file, right?
I'll do it.
Whether we recognize it or not is debatable, but it just depends on the scenario.
Whether you want to or not, I can't decide whether I want the water or not.
Yeah, absolutely.
So you're sticking it away from me.
Okay.
Yeah, so you don't mind sticking water away from me.
I don't know. I honestly have no idea what we're sticking away from anyone at this point.
Water away that I might be able to use.
Okay, if you say so. But I want to show one more feature of this, the website, for the benefit of everyone who's still online and for those who are staying here to look at the website. So on our home page here, there's an icon that says Adjudication. You go to that. It brings up this website, all right? And you may have seen this as part of the packet that you received. And if you go to Active Adjudications, at the top of the list is this Moab North Subdivision, and you can click on the map button that will get you back to where we were before, or you can select this and it'll bring up an interface that shows the different water rights that we're looking at, and it shows the status of those water rights as we progress through the process. So you'll notice they're all white color. They all have this white box next to them right here. That corresponds to the fact that summons has been served. Once we send notice to submit claims, those boxes will turn orange. And then when people file claims, those boxes will turn yellow. And then when we evaluate and review those claims, we'll turn it green. And then once we send back our recommendation to them, it will be turned blue. Now, if a water right doesn't get a claim filed on it, it will, and the 90 days expires, that's when it will turn red. And so you'll see, I can show you previous or other areas that we're kind of in the midst of doing this. We'll just kind of show you what that looks like. So if we go down to the holiday book, you can see that some have had their state engineer's recommendation made, they're blue. Some have claims filed, and some have notice to file claims served. Okay. Tell you what, why don't you and I can, we can hit, we can. I'm an engineer. Yeah. So are there any questions we can talk offline after this. Are there any questions about the, okay.
I don't have that there.
Yeah.
We got it right now. I'm satisfied with the moment.
Are you? Okay.
But moment will last about 30 seconds.
That's long enough, I think. Then we'll wrap this up and we'll get you back to being satisfied here shortly. I do want to show you where some forms are, just to make sure everyone knows where to go if everything else fails. You can go over here to the applications and forms, and then way down at the bottom, adjudication form. So you have a blank water user's claim form at the top, right here. And then you remember me talking about an extension to file claims for an additional 30 days. That form's there, but you can also just email me. That works just as good. You don't have to fill out the form. And then that last form is for documenting rights, not of record. So those are the grandfathered rights. If you have a water right from a surface source that you feel has been used prior to 1903, you would use this guidance on how to document that so you can have a diligence claim. If you had a underground water right that had been used prior to 1935, you'd use this same type of documentation to establish that that had been used prior to that date, and then you'd file a claim associated with that. So,
In that case of a surface, diligence claim, if that diligence claim is not full flow, will this adjudication process eliminate other water being taken from that aquifer or the spring that's being fed?
so I'm not sure I understand the question. Can you give me another shot?
Claim with so many CFS.
Okay.
And we don't feel that, we think that that's being drawn down, that it's not producing
Okay.
to that full,
To the full amount.
to the full amount. So through this adjudication process, would, if there's water, or water somehow that would be fed into there.
So the question is, you know, does the adjudication resolve any issues with respect to the availability of water? She expressed the interest that she has this diligence claim or this water right with a certain flow rate on it, but they're not able to get the full flow rate because the water is not there to get it. Does the adjudication help that at all? I have a hard time seeing the adjudication creating more wet water. The only thing the adjudication can do is get rid of bogus water rights, but the only way that they get rid of bogus water rights are for water rights not being used. And so if water is being used, and it's the only way you're going to get more water is if rights that don't exist are eliminated, right? And that's more of an enforcement action issue.
Right now, they may not be existing.
Yeah, so if they don't have a right to use the water, that's more of an enforcement action. And I would encourage you to talk to Mark Stilson, who can investigate whether people actually have a right to use that water, and or if you have a senior right, you can do a call on that water saying, hey, groundwater is a little bit trickier, but surface water, you know, those priority dates should work to the advantage of whoever has the senior right on the system. All right, I think that, any other questions? I think that wraps up the public meeting portion. I'm happy to stay afterwards and we can talk one-on-one and address any questions offline. Thank you very much. All right, Paul, you good?